Good evening and welcome everyone. My name is Alison Duxbury and I am the Deputy Dean of Melbourne Law School. It is my pleasure to welcome you this evening on behalf of Melbourne Law School and our Dean, Professor Matthew Harding, as well as the editors of the journal, the Melbourne Journal of International Law, to this lecture, the Sir Kenneth Bailey Memorial Lecture. I want to begin by acknowledging the peoples of the Kulin Nation as the traditional custodians on the land on which this lecture is being held, and I pay my respects to their elders past, present and emerging, and I extend this acknowledgement to all Aboriginal and Torres Strait Island people joining us today. You will shortly hear from our guest speaker, Associate Professor Ryan Lavoie. Following this lecture, there will be an opportunity to ask questions, and we will then have a vote of thanks from the editors of the Melbourne Journal of International Law, Tegan Evans, Matthew Carlisle and Nicholas Hui. Tonight's presentation is being recorded, and the recording will be available shortly on the Melbourne Law School website. The Sir Kenneth Bailey Memorial Lecture honours the fourth Dean of Melbourne Law School, Kenneth Hamilton Bailey, who played a significant part in Australia's contribution to the formation of the United Nations. Shortly after commencing his studies at the University of Melbourne, Bailey volunteered to join the Australian Imperial Force. After serving in France with the Australian Field Artillery, he was discharged and resumed his studies. Later, he studied at the University of Oxford, where he was a Rhodes Scholar. Bailey's expertise in international and constitutional law was called upon throughout his career. For example, he acted as an Australian envoy to the League of Nations in Switzerland and later as an advisor to the Attorney General's Department. In 1945, Bailey was asked by Dr. Evatt to be an advisor to the Australian delegation to the United Nations at the time when the Charter of the United Nations and the Statute of the International Court of Justice was being drafted. Recently, I actually had to examine some of the archival documents of the San Francisco Conference, which was the formation of the United Nations, and came across Sir Kenneth Bailey's very thoughtful comments in relation to the relationship between the United Nations and the specialised agencies. This year, the Sir Kenneth Bailey Memorial Lecture is also being held to mark the contribution of Professor Bruce Oswald, who after nearly 20 years at Melbourne Law School retired last year. It's particularly fitting that we celebrate Professor Oswald's contribution to the law school with this lecture because, like Sir Kenneth, he, as in Aussie, is both a practitioner and a scholar of international law. Now, when I first met Professor Oswald in 2001, he told me that the only person who called him Bruce was his mum, and that Aussie or Oz was the appropriate moniker. So that's how I'm going to proceed this evening. Aussie came to the University of Melbourne in 2002 from the Australian Army, where as a legal officer he has seen operational service in Rwanda, East Timor, Iraq and Afghanistan. He's also worked with the International Committee of the Red Cross, the ICRC, in the former Yugoslavia. He's provided legal advice and held staff appointments as a legal officer at tactical, operational and strategic levels, including with the Directorate of Operations and International Law at the Department of Defence. Aussie's scholarship focuses on issues of international humanitarian law, peace operations, state building, accountability and the application of human rights law to military operations. While at Melbourne Law School, he was a key figure in the founding of the Asia Pacific Centre for Military Law and served as its Associate Director and then Director. And I'm using the past tense to denote the fact that Aussie is actually retired, but he's still obviously an honorary professorial fellow with us and makes a contribution in that respect. Now, I personally have frequently returned and again to Aussie's work, including his book on documents on UN peace operations for my own research, and I've wandered down the hallway of level 9 of this building on countless occasions to discuss technical aspects of the law relating to international institutions or armed conflict and their application in particular situations. And Aussie has always been a very generous giver of his expertise in that respect. I want to finish my comments about Aussie before I turn to Ryan by paying tribute to his role in designing and delivering two subjects at MLS, Institutions in International Law and Global Lawyer in Geneva and New York, respectively. I emailed Aussie's former students in these experiential learning subjects to let them know this year that the Sir Kenneth Bailey Memorial Lecture would also mark Aussie's contribution to Melbourne Law School. I received many positive replies, and I know that some of his former students and Ryan's former students have joined us today. Many of these former students apologised because, unsurprisingly, they're now working overseas at various international organisations. This includes, for example, Robin Barnard, a lawyer at Human Rights First at New York, who said to me that Aussie played an outsized role in my law school career. Tonight we celebrate Aussie's outsized role at Melbourne Law School as a whole. So this brings me to our speaker tonight, another scholar and practitioner of international law. Associate Professor Ryan Lavoie is the Deputy Dean Research at the University of Queensland Law School, where he also leads the Law and Future War Research Group. He's also a Senior Fellow with the Liivoja Institute for Law and Land Warfare at the United States Military Academy at West Point. Before joining the University of Queensland, Ryan held academic appointments here at Melbourne Law School, where he was also a key figure in the Asia Pacific Centre for Military Law, and the universities of Tartu and Helsinki in Estonia and Finland, where he also completed his undergraduate and doctoral degrees. Ryan has been a visiting scholar at Georgetown University, the University of Oxford and the NATO Cooperative Cyber Defence Centre of Excellence, and he's also a visiting lecturer at the Estonian Military Academy. He's currently a visiting legal fellow at the Australian Department of Foreign Affairs and Trade. Now, Ryan's research focuses on legal challenges associated with military applications in science and technology. And with this expertise in mind, we've asked him to deliver this year's Sir Kenneth Bailey Memorial Lecture, titled Marching in the Rear and Limping a Little, International Law's Response to the Development of Autonomous Weapons and Cyber Capabilities. Please join me in welcoming Ryan this evening.
Well, good evening, everyone. I would also like to acknowledge the Wurundjeri people of the Kulin Nation as the traditional custodians of Naarm. Their sovereignty over this country has never been ceded or extinguished, and I pay my respects to their elders. Thank you, Alison, for the very kind introduction. As Alison mentioned, my affiliation with DFAT, I'm contractually obliged to preface my remarks with the usual disclaimer that any opinions expressed are my own and do not necessarily reflect those of the Australian government. It's great to be back at Melbourne Law School and a privilege to give this lecture, and I'm very grateful to the school and to the Melbourne Journal of International Law for having me here. And it's also wonderful to see some familiar faces in the audience. So as you've heard, this lecture series celebrates the life of Sir Kenneth Bailey. He was clearly an exceptionally accomplished international lawyer with strong links to Melbourne Law School, becoming a professor here at the ripe old age of 28 and the Dean of Law only a year later. Those were the times. He went on to have a very impressive academic, legal and diplomatic career, including as Australia's longest-serving Solicitor General. But today's lecture also recognises Professor Colonel Bruce Oswald, and this is a delayed celebration of Aussie advancing to the next stage in his illustrious career, namely becoming a full-time country gentleman. Like Sir Kenneth, Aussie has found a way to serve with great distinction both this university and the Commonwealth of Australia. I had the good fortune to teach a course on international humanitarian law with Aussie for several years, and I learned a lot from him. And Aussie's dedication to his students is, in my experience, second to none. So I'm delighted but not surprised that a number of his students have decided to join us this evening. So let's get to it. On 7 April 1966, two electricians were testing a switchboard at Mount Isa Mines in northwest Queensland. Lacking proper instruction, they misconnected their testing equipment, creating an explosion and an electric arc of intense heat. An engineer arriving at the scene found the two men literally charred and their clothes incinerated. He carried one of them through the powerhouse to an ambulance, only to be told several days later that the man had died. This Good Samaritan's mental health began to deteriorate, and he required extensive psychiatric treatment. He sued the company operating the mine, and the matter ultimately came before the High Court. Among other things, the court had to consider advances in medical science, in understanding mental illness, and how the law relates to such advances. One of the judges, Justice Windyer, dryly observed in his reasons that, and I quote, "Law marches with medicine, but in the rear and limping a little." I would suggest that His Honour's apt metaphor applies more broadly, including to the development of military technology and the international law that governs its use. International humanitarian law and arms control law have developed very reactively. Indeed, the main IHL instruments, the 1949 Geneva Conventions and the 1977 Additional Protocols, clearly reflect the experiences of the Second World War and the Vietnam War, respectively. If, as the saying goes, generals are always preparing to fight the last war, lawyers are always busy trying to regulate the last war. Undoubtedly, technological change can have a profound impact on the character of warfare, as precision-guided munitions and unmanned aerial vehicles have plainly demonstrated over the past few decades. This has clearly flow-on effects for the law. Yet the existing law seems to limp along with the development of military technology. IHL is largely technology indifferent. It seeks to achieve certain humanitarian outcomes, irrespective of what instruments of war are being used. Purposive interpretation of existing rules and going back to first principles does provide guidance even in the face of fairly radical technological shifts. Claims that technological changes have revealed massive gaps in IHL tend to be overstated and based on overly textual or historical readings of the law. That said, understanding how existing law applies to new technologies often requires close examination and clarification. This process may lead to the conclusion that, in some instances, there is a need to reinterpret or update the law. So this evening, I want to focus on the response of the international community to the emergence of cyber operations and autonomous weapon systems, or AWS, as an instrument of warfare. The reason for looking at these two areas of technology is twofold. First, for better or for worse, these are the areas of technology that have generated the widest legal debate in recent years, followed perhaps only by discussions about space operations. Other issues, such as military uses of bio and nanotechnologies, have, in contrast, remained the purview of a relatively small group of experts. Second, cyber operations and AWS are both ultimately facilitated by digital technologies. Accordingly, they share many strategic risks, for example, in terms of the speed of their proliferation. Also, cyber capabilities inherently tend towards autonomy because they are necessarily pre-programmed and often don't require real-time control. Yet, discussions about these capabilities have played out quite independently of each other in separate silos, both in academia and in intergovernmental fora. Now, I don't intend to get into the weeds of these rather technical discussions. Rather, I propose to take a broader look at the dynamics of these debates. But first, it is helpful to understand how we got to where we are now. Commentators on law and technology have noted that debates about the adequacy of the law tend to be triggered by technological crisis events. And these have been defined in the literature as the emergence of a specific technology that appears to have an uncertain future in that it promises both progress and peril. In the context of hostile uses of technology, however, that crisis is often much more specific. take the regulation of anti-personnel landmines, for example. Landmines have been used in some form or another for several centuries, without much of an impetus to regulate their use. But developments in the late 20th century changed the humanitarian impact of landmines. Some of the developments were technological, including the extensive use of plastics, which made mines more difficult to detect and less likely to degrade over time, and a wider reliance on remote delivery mechanisms. The resulting concerns were addressed in the 1980 Convention on Certain Conventional Weapons, or CCW, and in particular its Protocol 2 on landmines and booby traps. But this was not enough to address the growing problem. By the early 1990s, there was a genuine global landmines crisis, with more than 25,000 people killed or permanently maimed every year. The civil society managed to cajole states, and this is probably really the proper word, cajole states to act. So in 1996, states parties to the CCW, the Convention on Certain Conventional Weapons, tightened the Mines Protocol. And in 1997, states that did not consider this sufficient adopted the treaty popularly known as the Mine Ban Treaty or the Ottawa Convention. Now, with this process from a crisis event to legal development in mind, let's turn to cyber and to autonomy. With respect to cyber operations, discussions around their legal implications started in about the late 1980s. There was a first major academic conference held on the topic at the US Naval War College in 1999, and at the request of the UN General Assembly, a group of governmental experts, or a cyber GGE, was convened to discuss the intersection between cyber technologies, security, and international law in 2004. But there was no significant momentum at the time. The crisis event that jump-started the discussion took place in April and May 2007. In the context of rising ethnic tensions, the Estonian authorities relocated a Second World War-era monument from a central location in the capital, Tallinn, to a military cemetery. This led to riots on a scale not previously seen in the country and massive distributed denial of service attacks that temporarily crippled many government and commercial websites. Due to the heavy reliance on digital services in Estonia, the disruption was quite significant. Fingers were quickly pointed at Russia, although the matter proved to be far more complex. At the time, though, the Estonian defense minister spoke publicly about operational and legal uncertainties surrounding cyber activities in the context of NATO and in the context of the North Atlantic Treaty, the treaty establishing NATO. This incident, along with cyber hostilities against Georgia the following year, had a significant effect on the legal debate. Under NATO auspices, a newly established centre sponsored a process to examine the legal implications. An international group of experts, so eminent academics rather than governmental experts, produced 2 Tallinn manuals that examined in great detail the application of international law to cyber operations. And work on a 3rd edition of the manual has recently commenced. The incident also invigorated debates in the UN. 5 more cyber groups of governmental experts, or cyber GGEs, were held between 2009 and 2021. The General Assembly also created a separate open-ended working group, and in contrast to the cyber GGE with select membership, the working group was open to all UN member states, and it has operated since 2019 and continues to operate today. And all of these processes have played out against the background of significant and intensifying hostile cyber operations, which have emphasized the urgency of this endeavor. And the ongoing conflict between Russia and Ukraine is only the latest, but perhaps the most acute example. A recent report by Microsoft has described the Russian cyber offensive against Ukraine as relentless and destructive and strongly correlated with kinetic military actions. Now, with regard to autonomous weapon systems, or AWS, the origins and the context of the debate have been very different. As far as I can tell, The trigger was a 2007 opinion piece by Professor Noel Sharkey, a prominent AI and robotics expert at the University of Sheffield. In the piece, Sharkey called for international regulation of autonomous weapons at war, and several civil society groups were quickly formed to push for that type of regulation. The matter was then taken up by the late Professor Christoph Heinz in his capacity as the Special Rapporteur on extrajudicial summary and arbitrary executions. In a 2013 report, he expressed concerns about the compliance of so-called lethal autonomous robots with human rights and IHL. He recommended a moratorium on the technology and an intergovernmental dialogue to examine regulatory issues further. The next annual meeting of the states parties to the Convention on Certain Conventional Weapons, which I already mentioned, resolved to explore the questions related to emerging technologies in the area of lethal autonomous weapon systems by holding informal expert meetings. And these expert meetings were subsequently upgraded to another meeting of governmental experts or another GGE, this time the autonomy GGE. And this has held annual meetings since 2017. I should note as an aside that the term lethal autonomous weapon systems, which now circulates in the UN, owes a lot to the Christoph Heinz report with its focus on lethal autonomous robots. Lethality of the systems was important for Heinz because it brought the matter within his mandate on extrajudicial summary and arbitrary executions. But the lethality of weapons is not, however, a critical consideration from the perspective of IHL, which governs the use of all weapons. Consequently, the persistent references to lethality have caused difficulties in the autonomy GGE, where delegations have spent a considerable amount of time debating whether or not lethality is a defining feature of an autonomous weapon system. Now, developments in relation to AI have been regularly referred to in the autonomy group of governmental experts, and there have been some reports of increasingly autonomous systems being used in recent conflicts. But there has been no distinct crisis event. Worries about Russia's enthusiasm for autonomous systems have been eased by its complete inability to field them in the ongoing conflict. Indeed, in the ongoing conflict, Ukraine has been the greater innovator, effectively using off-the-shelf drones and 3D printed components to great effect. In short, unlike with landmines and cluster munitions and cyber warfare, advocates for regulating autonomous weapon systems have not been able to draw on evidence of humanitarian harm and have sometimes had to resort to feeding moral panic. Much of the debate has been vague and speculative in technological terms. There's also been no concerted academic effort to clarify how the existing law applies to AWS, although a lot of work is being done by individual scholars and research groups around the world. As a broad generalization, the scholarly analysis of the legal implications of cyber operations has become highly sophisticated and granular, no doubt helped by the Tallinn Manual as a useful starting point. Discussions on autonomous weapons still tend to focus on fairly general questions, such as whether or not they comply with IHL and whether or not they create an accountability gap. But this debate is starting to shift as well. So I now turn to the focal points of the intergovernmental discussions on cyber and AWS. In the cyber context, perhaps one of the biggest challenges has been the applicability of international law, including IHL. This foundational issue did not create any difficulty for the drafters of the Tallinn Manual operating in their personal academic capacity. They readily agreed that, quote, cyber operations executed in the context of an armed conflict are subject to the law of armed conflict. Where the drafters disagreed was in relation to the way the law applied, notably in terms of what kinds of cyber operations amounted to attacks. This is important because attacks are what are subject to the key IHL requirements of distinction, proportionality, and precautionary measures. However, the basic question about the very applicability of IHL to cyber operations caused considerable difficulty to the cyber GGE. The relevant IHL principles were mentioned as being applicable to cyber operations, in a 2015 report of the group, but disagreement over the express mention of IHL caused the consensus to break down in 2017. In particular, Russia and China argued that referring to IHL would contribute to the militarization of cyberspace. The CyberGG was able to overcome this resistance only last year, and this involved some deft negotiating, including by Australian diplomats. And I'm reliably informed that this involved the delivery of a bottle of wine and a bottle of vodka to the Russian negotiators. In the end, consensus over a reference to IHL was made possible by an express acknowledgement that IHL applies only in armed conflicts and neither legitimizes nor encourages conflict, which is really IHL 101. This problem never plagued the autonomy group of governmental experts. From the very start, there was a clear acceptance there that existing international law, including IHL, would be applicable to all kinds of weapons, autonomous or not. That said, a more technical discussion about how exactly compliance with IHL rules could be achieved when using autonomous weapons, and how human rights law enters the picture, has proven elusive. Indeed, some delegations have resisted such a discussion because it would, in their view, legitimize the use of autonomous weapon systems. One of the biggest stumbling blocks for the autonomy GGE has been a persistent lack of agreement about what technology is being discussed and where legal or moral lines should be drawn. Emblematic of this problem is the reluctance of the GGE to expressly talk about autonomous weapon systems because there is no agreement as to whether such things already exist or not. This has led to the deployment of the mind-boggling phrase, weapon systems based on emerging technologies in the area of lethal autonomous weapon systems. In both the cyber and AWS contexts, there has been significant disagreement over whether new law is necessary or desirable. Many Western countries, including Australia, have taken the position that, existing law being fully applicable and sufficiently robust, there is no need for a new legally binding instrument on either cyber or AWS. At the same time, many of these states have admitted that various measures to understand or clarify the law or to establish best practices would be useful. In both the cyber and AWS contexts, however, there are some states that think that new law is essential. And this sentiment is more widely held with respect to autonomous weapons, where a sizable number of states want to negotiate a legally binding instrument containing some combination of prohibitions and limitations. Now, interestingly, Russia has been at the extreme opposite ends of these two debates. In terms of cyber, Russia has been the strongest proponent of a new treaty, which it deems necessary to prevent the militarization of cyberspace. In the AWS context, it has been one of the most ferocious opponents of any new treaty or even a politically binding outcome document. The general reluctance among many states to embark on treaty making with respect to these two technologies has led to non-legally binding measures, or for those of you who like that term, soft law. With respect to cyberspace, the Cyber GGE in 2015 elaborated 11 voluntary, non-binding principles, rules, or principles, non-binding norms, rules, or principles of responsible state behavior, which included things such as not engaging in or supporting conduct that intentionally damages critical infrastructure and cooperating and exchanging information in relation to cyber incidents. With regard to AWS, in 2018, the Autonomy GGE adopted a report that contained what were titled possible guiding principles, the word possible having been inserted at the request of a cautious Chinese delegate. These principles cover matters such as the applicability of existing international law to autonomous weapons, the non-delegation of responsibility to machines, and the need to undertake legal reviews of new weapon systems. The following year, an additional principle was added dealing with the importance of human-machine interaction in ensuring compliance with IHL. Also, the word possible was deleted from the phrase possible guiding principles, a change that may have been facilitated by the Chinese delegates' momentary lack of vigilance at the end of a long session. The autonomy GG in particular is now at a crossroads in terms of what to do with the guiding principles. In March this year, a group of 6 delegations, including Australia, proposed to expand on the principles in the form of a non-binding document containing principles and good practices. Other delegations proposed to push ahead with negotiations for a new protocol to the CCW, that is to say, a legally binding instrument. Interestingly, the UK submitted a proposal to develop a manual that would constitute an authoritative and comprehensive statement of the application of IHL to autonomous weapons systems and agreed best practices. This proposal was clearly inspired by and envisaged something similar to the Tallinn manuals on cyber operations and the earlier Sanremo manual on naval warfare. But as I mentioned, the Tallinn manuals were drafted by a group of eminent scholars in their personal capacity. The result was therefore an academic product, not necessarily reflecting the views of NATO that sponsored it or its member states. However, the UK envisages the Autonomous Weapons Systems Manual to be owned and completed by the group of governmental experts. I think the prospect of such a manual ever materializing is rather dim. First, even though the term group of governmental experts has the word expert in its title, the reality is rather different. Most of the people participating are in fact not experts on military, technical or legal matters, but they are diplomats. Only a fraction of the states have the resources to deploy expertise necessary for such a manual drafting exercise. Second, it took a small group of like-minded experts operating in a single common language several years to produce the Tallinn manuals on cyber. Your guess is as good as mine in terms of how long it would take a highly diverse group of representatives from 125 states parties to the CCW, operating via interpretation in 6 languages, to complete a similar process for autonomous weapons. Finally, I want to touch upon the current geopolitical climate, or to put it more succinctly, Russia. The international fora that I have been talking about are all based on consensus. Relying on consensus has the advantage of coming up with arrangements that are agreeable to a large number of states. These arrangements hold the potential to become universal. At the same time, they involve reducing the outcome to the lowest common denominator, and also individual states can thwart collective efforts. The most recent Autonomy GGE meeting that took place from 7 to 11 March this year, just 11 days after Russia invaded Ukraine, demonstrates this vividly. And what transpired in that meeting gives a sense of the troubled waters ahead. By the time the group convened in Geneva, Russia was the subject of a range of sanctions. These included the closure of European airspace to flights to and from Russia, or involving Russian aircraft. Switzerland had also suspended an agreement whereby Russian diplomatic passport holders were exempt from visas when traveling to Switzerland. The Russian delegation relied on these travel restrictions to argue that it was being discriminated against, as their full expert delegation was prevented from arriving from Moscow. Switzerland quickly put it on the record that no Russian diplomat had been denied a visa. And the US delegation helpfully pointed out that travel via other countries, such as Serbia, Turkey, or the United Arab Emirates, still remained a possibility for the Russian delegates. For good measure, Ukraine also noted that their full delegation was prevented from traveling to Geneva because they were busy defending Kiev. An acrimonious debate around these issues consumed 2 full days. The lack of consensus on formally proceeding with the meeting led to the remaining 3 days to be conducted as informal consultations, which are not readily accessible to the public and are not officially recorded. The first cyber working group meeting this year took place in New York only a few weeks later, from 28 March to 1 April. Unsurprisingly, considerable squabbling took place, but of a slightly different kind. Here it needs to be recalled that the cyber working group under the UN was set up as a Russian-sponsored initiative, as an alternative to the earlier cyber group of governmental experts. Several delegations clearly thought that it was time for Russia to taste its own medicine. At the start of the meeting, the US and UK objected to the proposal to adopt a program of work, which is basically like an extended agenda. They pointed out that the way civil society groups could participate in the working group had not been agreed, and that it would be irregular to start a session at the UN without agreeing to all of its modalities. The US proposed, surprise, surprise, to continue the meeting in informal mode. Russia refused, and considerable bickering ensued. Ultimately, Russia accepted to have the second session take place in informal mode. So, what to make of all of this? I can offer three general takeaway messages. First, the debate about the regulation of new technologies that have an impact on national security is fragmented across different fora. I've talked about the cyber GG, the autonomy GG, the cyber working group, and I should also mention the separate outer space GGE. They all deal with similar or interrelated legal issues, notably the application of IHL to new technologies or domains, yet they operate with different mandates, aims, and participants. Second, by default, such international fora operate based on consensus. This allows even a single state to hold the entire process hostage. This problem is only compounded by the increasing international tensions that involve major military powers. Third, even in the context of international security, arms control and disarmament, which have traditionally favored treaty-based solutions, international processes are turning to non-binding instruments or soft law. While appealing as a way of breaking deadlocks and achieving tangible outcomes, this can undermine hard law and create its own compliance problems. So this is all very doom and gloom, and I don't want to leave you this evening without a sense of hope for the rules-based international order. So here are a few things that perhaps can be done. First of all, coordination among like-minded states and between government departments within states may help alleviate the incoherence internationally. When states advance coherent positions in different international fora, they assist in aligning the disparate debates. Second, publicly articulating national positions is immensely important and helpful. This allows the civil society and the wider public to understand how states approach certain issues, especially in circumstances where the international debates are conducted behind closed doors, as was the case with the cyber GGE, or when they are switched to the inaccessible informal mode, as was the case with the autonomy GGE. Crucially, national articulations of legal positions amount to opinio juris for the purposes of developing customary international law, which has special significance in circumstances where treaty negotiations prove to be impossible. Third, states must be prepared to use alternative fora, where progress cannot be prevented by a small number of states breaking consensus. Sometimes this option is beneficial for a particular state, sometimes it is not. But the dynamic of a forum where decisions can come to a vote is quite different from one where decisions can only be made unanimously. On 17 March 1972, this university conferred upon Sir Kenneth Bailey an honorary doctorate of laws. During a special ceremony held at Canberra Hospital, Sir Kenneth had this to say, and I quote, "Our world is one of change, and to this the law is no exception. Its prime task is to lay down the ground rules by which the conduct of man in society is regulated. But in this there is always involved some degree of peacekeeping. Violence is, to a greater or lesser extent, a common factor in human society. It is one of the tasks of the law to contain the social violence." And while these words were said with reference to domestic political violence that plagued many states at the time, the sentiment surely resonates with us as we consider the state of the international community 50 years later. Thank you.
So thank you very much, Associate Professor Lavoie, for that very comprehensive discussion of the law relating to autonomous weapons systems and also cyber operations, or perhaps what the law may or may not be. I now want to open the forum for questions. So if anyone has any questions, please put up your hand. I've got a couple, but yes, Jeannie.
Oh, two. Thanks for a fabulously interesting presentation that I think resonates with international lawyers and humanitarian lawyers and normal lawyers as well as the general public. I mean, I guess my question to you is, you finished with a comment about the lack of coherence with the reaction to cyber and to autonomous lethal weapons. And I wonder if that difference partly lies simply in sophistication of the technology that exists in the here or now. I mean, you made the comment that we've got a lot of debate about what autonomous lethal weapons even are. They're not here yet. Where cyber attacks are here, and the more societies rely on digital technologies, the more open to those attacks they are. So is that sort of incoherent, the fact that one is the here and now and one is the far-off future that may or may not arrive?
Look, I think there are multiple factors there, and that is certainly one of them. My sense, at least, is that the legal discussion around autonomous weapon systems lags about 5 to 10 years behind the legal discussion on cyber operations. It's just not as sophisticated. But I think there's another problem, which is that because the fora are different, the portfolios within governments tend to be held by different people, and who don't necessarily sort of align their positions in relation to those particular fora. I think Australia is something of an exception in the sense that there is quite a lot of interdepartmental communication between Attorney Generals, the Office of International Law, DFAT, that leads negotiations, and Defence that uses the technology. So I think Australia tends to be on the same page in these different fora, but that's not necessarily true for other states, which send a true cyber expert to the cyber GGE and then someone from the Ministry of Defence who deals with disarmament affairs to the autonomous weapons GG.
Thank you. Carrie McDougall?
Thanks very much, Ryan, for a really interesting presentation. I have two questions. I don't want to be greedy, so feel free to pick one of them and I'll pester you after the event for an answer to the other. One's on process, one's on substance. The process one, I was really intrigued by your suggestion for a way forward, that it would be beneficial to have more debates in formal settings, so they're on the record. Absolutely accept that statements made in such meetings can, in certain circumstances at least, amount to custom in international law, and therefore it makes academic lives easier. But in my experience as a former diplomat, the real work is still done in the corridors, not in formal meetings that are recorded. So is it realistic to suggest that states will be talking about matters that are so central to national security in open fora, particularly when it might be required capabilities to be revealed at some point in order to get granularity in the legal discussion? Excuse me. The substance question, which you might be more attracted to, is you painted a really key picture about how legal discussions are trailing technology, at least in the cyber domain. But I think the discussions also focus very clearly on offensive capabilities, and there's not a lot of discussion about defensive capabilities. And I was wondering if, in that context, you had any thoughts about ongoing work being done by the Red Cross and others in relation to the creation of a possible digital weapon.
Thanks, great questions. I think there are interesting issues around sort of defensive uses and beneficial uses of technology, even in the autonomous weapons systems context. So, for example, a technological suggestion that has been proposed and is being tested is to have a weapon system that has the autonomous capability to identify protected emblems, for example. Such that it actually operates as a sort of a fail-safe mechanisms if a combatant fails to notice an object that is deserving of protection. And clearly no one has any sort of issues with the use of autonomy in that sense, except perhaps the concern that the users of the system will start to over-rely on that and then sort of basically lose their own vigilance in looking out for protective objects. So certainly I think there is a broader conversation to be had, both in terms of the humanitarian benefits of autonomous functionality in that context, but also around technological changes that would be required or would be helpful to better protect humanitarian agencies. Now, coming to your first question, I take your point, but I suspect that having conversations behind closed doors would work better with relatively small groups. So if we think about the autonomy GG, for example, it has 80-something participants. So it's not really behind closed doors. It's simply very inconvenient for the civil society and academia to participate. And I think that's a problematic position to be in. Look, if there are good reasons for having a debate behind closed doors between governmental representatives, that's fair enough, and that might be conducive in certain circumstances. But this sort of halfway house where we simply make life complicated for NGOs, I don't think that's particularly attractive.
Thank you. At the very back.
Thanks for really interesting talk. Just wanted to ask a bit of a, I guess, definitional question in a way, but also how much do you think use of the term such as autonomy is beneficial, because with AI, we know that it's a ground word in many ways, and something like autonomy, semi-autonomous, that obviously affects what the object of regulation is. And that links to Jeannie's question and carries in a way that we're talking about offense, defense, or lag, all comes down to exactly the capabilities. So what sort of definitions are prevailing definitions? And to what extent do you think we need to, I guess, specify the nature of the technology that we're talking about when thinking about naming things like autonomy, PGP, and to what extent is that helpful to use something like autonomy?
Thanks. I mean, perhaps the most common definition is an autonomous weapon system is a weapon system that, once activated, can select and engage targets without further human intervention. And this is a definition that is used by the world's most significant military power, the US, and the world's most significant humanitarian organization, the ICRC. So probably safe to go with that. But there are competing definitions which are, for various reasons, exceedingly narrow. So, for example, the way in which China and France have in the past defined autonomous weapons is so limited that nothing would probably ever qualify as an autonomous weapon. And that is clearly driven by the worry that there will be some sort of a legal instrument prohibiting these things, and the more narrowly these systems are defined, the better in terms of our room for maneuver. But I think some of the difficulties around the use of the term autonomy is that different disciplines use them very differently. So autonomy means something of a very, very high standard to philosophers and lawyers, whereas it means something relatively mundane sometimes to engineers. And that needs to be clarified. And I mean, the way in which the ICRC and the US government use the term sort of aligns more closely with the sort of engineering definition of autonomy. So if there's a system that is capable of performing some function without direct input from humans, it has a degree of autonomy in relation to that function. And that accepts the proposition that autonomy is really some kind of a spectrum, that a particular device can be autonomous to a greater or lesser degree in relation to a particular function, and sort of does away with these sort of strict distinctions between fully autonomous and semi-autonomous, which have been sort of have been circulating in the GG context and elsewhere, but no one has really found a principled way of distinguishing between a fully and a semi-autonomous weapon system. So I think this sort of spectrum approach, where we accept that there's a large number of weapon systems that potentially can be considered autonomous, but that only some of them are problematic and might require legal regulation. I think that probably would be the way to go.
Thanks. Angus?
Thank you for your lecture, Brian. Based on the materials that you've been looking at and recently produced, unlike, say, plastic landmines, is there a Goldilocks zone in which some of these technologies are accepted to be used and not wholly prescribed? Because there might be some general societal benefit in using certain autonomous weapons instead of having a soldier on the wall, or attacking a power grid instead of sending in a battalion. Is there a recognition that some of the use of this sort of technology is good, or is total prescription tamed out?
There is certainly recognition of that among many of the governments that develop and use that type of technology. But there are equally governments that are very resistant to arguments that autonomous functionality might be beneficial or might be humanitarian. But I mean, there are examples of weapon systems that are plainly autonomous in their operation. The close-in weapon systems or CWIS-type weapon systems that have been used on naval vessels for decades, no one really doubts that they're useful, and no one really doubts their utility in protecting the ship as sort of the last line of defense. Equally, sensor-fused munitions which are launched towards, say, a tank column, and which at the very end of their trajectory pick a particular tank to attack, no one is really suggesting that they are problematic. But at least initially, the push for a very comprehensive ban on autonomous systems would have covered those types of systems as well. I think the international debate has moved away from that, and there's an acknowledgement that we're not really worried about every weapon system that has some autonomous functionality, but then that raises precisely the problem of how do we draw the line. Some have said that, well, we should exclude defensive systems from any future prohibition. Some have said that we should exclude anti-materiel weapon systems from any future prohibition. So it comes again back to the question of where do different groups of people and where do different governments draw the line.
Thank you, and I think it's appropriate that the final question goes to Professor Oswald.
Thanks, Alison. Thanks, Alex. Great presentation. And I'm just ripping off the last two answers that you've given. Is it your sense that this is a conversation in relation to autonomous weapons that has a large humanitarian focus because of the effect it has on people? Or is this really an arms control conversation? And it might be a combination of the both, but where do you have a sense of where the heavy lifting is being done?
So I have a generous answer to that and a cynical answer to that. The cynical answer is that professional arms control advocates needed a new project, and autonomous weapons were it. And they're using tactics that are quite similar to the processes that led to banning of anti-personnel landmines and cluster munitions, and which were successful in those cases. But there was a clear humanitarian disaster that they could actually point to and say that a legal regulation is a solution to that. I think that has proven to be quite a challenge in the autonomous weapon systems context, where the same patterns of argument simply do not fit particularly well. The generous argument is that there clearly are people, particularly folks who develop autonomous systems, who are quite concerned about the way in which their work might be utilized by governments or by terrorist groups. And so, particularly at the early stages of the campaign to regulate autonomous weapon systems, there were lots of interventions by folks like Professor Sharkey, basically saying that we as developers of technology want you, the governments, to make sure that this isn't being used for evil. So I think there are these, both of these tracks are present there.
Thanks very much. I actually have one more question, sorry, and then I'll hand over to Angel. Sorry, Ozzy, I had to do this. So it's often said in international humanitarian law or the law of armed conflict that the law relates to the last war. So that, it's because of the last war that the law develops. Do you see any particular developments that might occur in the law because of the war that is occurring at the moment between Russia and Ukraine?
I think it probably will add intensity to the discussion around cyber warfare and the legal rules that apply to it. Because even though the press perhaps doesn't cover it to the same extent that it should, the cyber hostilities in Ukraine have been quite intense. So certainly it would add to that conversation. Another thing which I think is quite interesting is the use of sort of fairly basic off-the-shelf technology, the stuff that you could buy from JB Hi-Fi by the armed forces. And I think that raises significant questions in terms of how export control mechanisms work. So the mechanisms that are designed to prevent military technology from being exported to countries where they are misused or where they end up in the hands of terrorist groups. And I think what Ukraine is doing is demonstrating that these frameworks don't necessarily hold as much value as they used to, and might lead us to rethink that a little bit.
Thank you. Well, thank you very much, Ryan, on behalf of the law school, but actually I'm going to hand over to the Melbourne Journal of International Law editors. I think in particular it's Tegan Evans, to give the vote of thanks this evening.
Well, we have a small token to thank you to begin with. You're welcome. And as all of the people asking questions have noted, obviously that was a fascinating presentation, and thank you so much for your insightful comments, which are, as you've noted, incredibly timely in the current situation. And we look forward to revisiting it as a recording. And thank you also to Alison for helping to organise this event alongside us. And as she noted in her opening remarks, we'd also like to take an opportunity to thank Ozzy for his contributions to MJIL over the years. As a professor to many of our members and editors, an advisor to the journal, and a friend to many of us over generations of MJIL, his generosity of time and experience, as well as many anecdotes of armed conflict and peacekeeping that never failed to put the trials and tribulations of being in law school into pretty sharp perspective. And finally, we'd like to thank all of you for coming, and we'd just like to say that it's such a pleasure to be running these events back in person again. And we look forward to seeing all of you at these events in the future and on our lecture next year. And thank you for being part of the international law community at MLS. We're so thrilled to see you all again. Thank you.